when you're getting ready for your taxes and your audits, that's a good time to kind of get your reports updated. It kind of keeps you in check too, to make sure that your entities, that you're keeping your information current and whatnot and in line. And not to mention, with certain lenders now, even for construction loans, we do have to provide some beneficial ownership or KYC documentation. So, and I'm sure we have some reps and warranties, at least that I've seen, and loan documents. So you're also keeping in line with your current agreements that you're under and making sure your reps and warranties aren't in default either. So it's just one more thing to keep you in check on certain in your day-to-day practice.
Welcome to Deals and Developments, a real estate podcast from the Dykema law firm. I'm your co-host, Teresa Ereon Giltner, partner at Dykema and member of the firm's real estate practice group.
And I'm Kacy Cigarroa, senior counsel at Dykema and also a member of the firm's real estate group. For more episodes, you can find us at dykemapodcast.com, youtube.com/Dykema Law, or by searching Deals and Developments wherever you get your podcast.
On today's episode, we'll be discussing the Corporate Transparency Act, or CTA.
Thanks, Teresa. Looking forward to discussing this further. So I am a commercial real estate attorney. I've been practicing since 2010 here in Texas. I've had the privilege and the honor of joining Dykema in October of 2023 and excited to be a part of this team. I'm also on the Corporate Transparency Committee here at Dykema and look forward to talking more about the Corporate Transparency Act.
That's great. Kacy, I've been practicing a little bit longer than you for about 38 years, but I consider myself as always learning. I'm looking forward to learning more about the CTA and how I can apply that to some of our real estate clients. So let's get started. Going over some of the basics. What exactly is the CTA and what is the objective?
So the Corporate Transparency Act was actually enacted it became effective in January 1st, 2024. And it was enacted as part of the Anti-Money Laundering Act of 2020. And it was aimed to assist law enforcement in combating money laundering, tax fraud, financing of terrorism, and all those bad activities. So they decided to come up with this Corporate Transparency Act. Very broad, but at least, now we're kind of scrambling and trying to figure it all out. And that's what the focus is today. We're trying to prevent all those money laundering activities. So we file certain reports and we submit those reports to the Department of Treasury's Financial Crimes Enforcement Network. I'm going to be referring to that as FinCEN throughout this process.
Okay, so how does an individual real estate company determine whether or not they fall under the purview of CTA? I know that there are size or number of employee type things, and perhaps it's related to revenue. I'm not sure, but how does any individual company know whether or not they need to be filing a report and be concerned with the CTA?
Look, so great question. So the first step would be one is to determine whether you're a reporting company, and you'll kind of go through that to find out, okay, am I a domestic company? So am I formed in the United States? Am I a corporation? Am I an LLC? And am I a limited partnership? Or do I need some kind of filing formation certificate to be filed with the Secretary of State to be formed? So if you answer yes, those are all the reporting companies. It also applies in connection with a foreign reporting company, and that is a corporation, an LLC, or other entity that's created under the laws of a foreign country, but it's registered to do business in the United States. If that applies, then you're a reporting company. So if you can check those boxes, then the next step would be, am I exempt? And there's like a long list, 23 exemptions that you have to go through to find out if you're exempt. And so I can go through that, but most of it is like banks, insurance agencies, large corporations. So if you're a real estate development company, probably your parent corporation or parent entity, if you're making over a certain dollar amount, then you probably could qualify as an exempt entity, but you would have to file your tax returns and whatnot to determine that. So once you figure out, am I exempt, going through that long list of 23 exemptions, then you just have to say, okay, I'm an exempt entity. If you're not an exempt entity, then you have to file a report with this with FinCEN.
Kacy, looking at the numerous exemptions, what would be a kind of a threshold one for smaller real estate development companies or smaller companies? I know that I work with a lot of companies that have, like maybe they develop apartment complexes, maybe they develop office buildings, or maybe they own shopping centers. I mean, I have a great client who does a lot with thrift stores. So they do have employees, but maybe the real estate is owned in one entity and the operations are in another. And I know that kind of goes into what you were talking about of reporting company versus the ownership. But some of these folks may only have, say, 10 real employees and then have the employees sitting in another company that do the actual work, or hire like a property management company or hire a management company to do the others. Do those folks need to be concerned about the CTA?
So for like a large operating company exemption, you would have to meet the following criteria. You need like 20 plus full-time employees, plus a U.S. income tax return for the previous year showing $5 million plus gross receipts. So let's say you have your operating company, which is typical in a real estate development firm. If they meet those requirements, you would be exempt. So you would still need to file that to show that you're exempt.
Yep.
So to let them know. And you also have to have an operating presence at a physical office in the United States. The other scenario where you have maybe 10 plus employees, you would still have to, I would assume it would be a reporting company. And because sometimes it's just one of those where you're setting it up to enter into contracts, just as kind of the shell entity entering into purchase and sale agreements, which you'll eventually get assigned later on. Anyways, so those I presume will definitely meet the reporting requirements if they're an LLC or a corporation.
And so when they're filing a report with FinCEN, and I think that's who you said that the report goes to, when they file it with FinCEN, is it just like a one-page report? Is it kind of a summary report? Is it something they can do themselves? Or do they look to their accountants or to their attorney or perhaps a filing service to prepare those on their behalf?
So I would probably advise at least our real estate development clients to at least pick one person within their company to be the filing person. So they would need a FinCEN ID, and all you have to do is type in the FinCEN address and get a FinCEN ID. So they're the ones that are submitting the reports on behalf of the reporting company. You'll need the reporting company itself. Let's just say I have Kacy LLC, and it's a reporting company. I'll need to provide my legal name and any trade name that I'm doing the business under, the address, the jurisdiction that I'm formed, so like in Texas, and of course the taxpayer identification number. So that's one that we'll have to put in. Then you'll have to go into the next level, which is your beneficial owners. All right, so you have your reporting company, you meet that threshold, then you get the beneficial owners. And then the beneficial owners of each reporting company will have to put in their full legal name, date of birth, address, and unique identifier, which is the FinCEN, some kind of passport, driver's license number, and whatnot. An official owner under the FinCEN requirements is someone that directly or indirectly exercises substantial control over the entity or owns or controls 25% or more of the ownership interests. So with some real estate clients that I've worked with, I've actually developed kind of a master spreadsheet where, for most of their entities, if you update them, and this is where it's very important. I know we all get busy, but I would advise the real estate clients, development clients, to keep that information up to date, because if there's any kind of change in ownership interests or any kind of substantial control or whatnot, where you have to report that to FinCEN. Even if you change your office address, you have to report that to FinCEN. So creating kind of a master spreadsheet concept and having one person in charge of that would be beneficial to them in making sure that all their entity information, all the individuals that own that information, they can have access to that information, is very helpful, and it will actually make the process a lot easier when you're putting in or filing those reports. Is it a one-pager? No, I think you have to go through several steps. You have to log in, put in that information, answer several questions. So I think it's several pages, but you would have to do that on by accessing the reporting website itself.
Okay, and so in listening to what you've just said, is it kind of a, if you are exempt, is it a one and done that you file this information showing, okay, we surpassed the income level, we surpassed the number of employees, our ownership does change throughout the year. Do we have to then file this every year showing that we're exempt, or is it, as long as the exemptions remain, as long as we did it the first time, we're good?
So as long as your exemptions remain, that should be good for the first time. But if it changes and you're no longer exempt, you would need to report that.
Okay. So if you've got a real estate company that's, maybe perhaps in the process of winding down, or has just decided to spin off or to sell a bunch of its assets, then it may find itself subject to the CTA, even though in prior years it was exempt from it. Is that
correct? So it also, depending on prior years, how long ago it was formed, assuming it was formed within, let's just say the past 2 or 3 years, pre-2024, you have a grace period till end of 2025 to file your report to whether you're exempt or not. But if there is gonna be a change that would disqualify your exemption, you would probably need to report that.
Okay. And again, when you're reporting, this is something they can self-report. They don't necessarily need to use a service or an accountant or an attorney to do so.
So there is actually, you can hire a CT Corp, those filing agencies that actually Capital Services, they actually can help file it for you. You would have to answer some kind of online questionnaire, kind of a get to know you type deal.
Sure.
And your information. So they can do that for you for a fee. And they would be able to do that for you. And then they take on that responsibility of filing. You would also have to provide them the information, but at least they're the ones that are submitting the information and whatnot. Or you can have someone in your development company doing that for you as well.
Okay. And so, what are the benefits, would you say, to a real estate company for complying with the CTA? I mean, besides the obvious that it's the law, that we want them to do it and we don't want our clients getting into trouble. But, I'm sure that from a client perspective, I'm sure that many of them, this is just yet another thing that they've got to do, right? And I'm sure that a lot of clients weren't very thrilled or haven't been very thrilled to learn about the CTA because, again, it just, while the end result may be something good for our country and for humanity, it doesn't necessarily make one's day easier.
Right.
That can be difficult. Those can be not fun conversations with clients sometimes.
Right. And it's just one more thing that they have to do, like you said. And it's just, it's part of the another requirement that we have to fill in. So I like to think of it, okay, when you're getting ready for your taxes and your audits, that's a good time to kind of get your reports updated. It kind of keeps you in check too, to make sure that your entities, that you're keeping your information current and whatnot and in line. And not to mention, with certain lenders now, even for construction loans, we do have to provide some beneficial ownership or KYC documentation. So, and I'm sure we have some reps and warranties, at least that I've seen, and loan documents. So you're also keeping in line with your with current agreements that you're under and making sure your reps and warranties aren't in default either. So it's just one more thing to keep you in check on certain in your day-to-day practice. And keeping your files current too, because there's so many times where entities go into, involuntary termination and whatnot. So at least, now we know, oh, these are my current entities and this is what I got to do, or do we need to terminate this or dissolve, liquidate and whatnot. And also avoid you from paying any kind of penalties. There's some real dollars at stake here.
Well, let's talk about that. What are the deadline? What are the current deadlines, and what are the penalties that folks are looking at if they were to misfiling in accordance with the CTA?
So the effective date, as I said, is January 1st, 2024. So if you formed a company after January 1st, 2024, then you have within 90 days after you formed it or when you actually received notice to file your report.
So not very long. So anything
not
that's filed
So if you filed it this year, so for instance, if I filed something for a new transaction, a multifamily development deal I would have 90 days to file that report. I would also, just kind of a segue into this, is I would also make sure your entity documents include some kind of CTA language or some beneficial ownership reporting requirements, just because you got to let your partners and investors know that, hey, you're going to be coming around asking for some personal information, and you're going to have to share that with some folks. So at least putting it in your company agreements and whatnot would help you in the long run. And then also determining some kind of communication method with your investors or partners on how to obtain that information on a forward-going basis. So just that little segue on that part.
That makes good sense. So if it was formed, if you have a real estate company that's subject to the CTA that was formed prior to January 1, 2024, how long do those entities have to file their initial report and make sure that they stay away from any penalties?
They have until January 1st, 2025.
Okay, so they get all of this year in order to get that together. Okay.
Yeah, which is helpful because, I mean, I'm sure there's numerous entities, especially for like a real estate development company, when you have shells and whatnot for each transaction, and you create a new entity probably for each, either a multifamily development deal or for any kind of retail office, whatever you're working on. I'm sure there's several entities involved there for each transaction. And then after that, January 1st, 2025, I believe you have 30 days. So it gets shorter.
And then what kind of penalties are they? Are they monetary? Are they things that you go out of compliance with your individual state? What are the penalties for not complying with the CTA on a timely basis?
Well, first of all, you can't provide, knowingly, willfully, any fraudulent information. Obviously, you want to make sure that you're providing all the information. And if you create a reporting violation, you're liable for civil penalties of not more than $500 for each day that the violation continues or hasn't been remedied. And you may not, I think it may be fined not more than $10,000, and you may be in prison for not more than 2 years or both. So
wow. So there is a potential criminal part. I mean, in terms of actual personal liability for that as well, in terms of a prison sentence, in addition to a monetary fine. Not that I'm suggesting that anyone would want to incur a fine either way, but it goes beyond just money. So, and that's important.
Yeah, and you can. I mean, if you hadn't remedied the violation, like you said, there could be a criminal penalty for up to $250,000 and 5 years in prison if you knowingly disclosed or used the beneficial ownership information in a false or misused it improperly. So, I mean, there's some real dollars and damages at stake here.
No, I could see that I could. Well, and I can also just see a lot of folks being caught unaware, at least initially,
right,
from this, which is why I think it's good that we're talking about this today. What about in terms of, you briefly mentioned this, in terms of loan documents, whether we're talking about on the borrower side or on the lender's side, do you foresee that in the future that lenders may include a covenant that's more specifically related to the CTA? I mean, there's often a covenant that relates just, generally to legal requirements that an entity is compliant with all, state, federal legal in the laws or what have you. But I'm wondering, given the penalties and given the importance of this, whether or not we're going to start seeing something more specific, and frankly, whether or not I need to change some loan documents on the lender's side to include something like that.
Yeah, I mean, I've actually thought about that, and I think that I've actually even created language just in case that the lenders either may be subject to it, or that we may, the borrower side, like that, hey, we're going to follow the BOI rules or KYC rules. But also from the lender's perspective, I'm curious as, do they even have consent now to access that registry? And then also, do they need to get our consent to access that registry? And maybe we need to include that in the loan documents to obtain that, just to implement whatever processes they need to do on their end.
Yeah, because I'm just thinking from a lender's perspective, I certainly want to make sure that my borrower is doing what they're supposed to do. And because I want them to repay me, I want to make sure that to the extent that they have to expend funds, that those funds are going first to pay me and, not having to deal with paying some sort of civil fine or penalty. And would not be happy to learn that as a lender, that somebody was out of compliance in that way. So
I agree. I do think that lenders need to be aware or at least look at their loan documents to implement some kind of compliance obligation during the life of the loan, or build appropriate language in the loan agreement, like even if, like, for instance, the borrower becoming a non-exempt entity too. So looking at it from that perspective, if they're currently exempt and become non-exempt, or vice versa. So
yep. No, and I can see that there may be some generic language in most good loan documents today, but I think this is important enough, as it was, especially after 9/11, when we started to see a lot more of the KYC type language, that it be in there very specifically, just to make sure that everyone knew exactly what we were looking for and what was being asked. So,
and I'm kind of curious to know whether that's going to be, for instance, if you have like a replacement guarantor, developer, or manager concept. If, I'm sure you've already kind of loan documents considered, the KYC rules, meeting those rules already, that, if they're including in those provisions as well.
Yep. It's just another layer. Okay. I also wanted to mention, I know that Dykema has produced a e-alert for the Corporate Transparency Act. So that's something that our listeners could look to. Also, Jeff Gifford recently did a 1 Minute Matters, giving a very brief, I listened to it and I think it was literally 1 minute, maybe a few seconds over, but about the Corporate Transparency Act. And in speaking with you today, Kacy, I feel like that we've just kind of touched on the surface, and that we're all going to be learning a lot more as we go forward as folks, and frankly, FinCEN, kind of deal with what we're talking about today and the nuances of it. I mean, I think that we've seen in other laws, our compliance laws, that as time goes on, especially with something new, that those rules sometimes get changed a little bit as the governmental entity sees the response and how those reporting companies deal with it. So I think this is going to be an ongoing topic for a while people get used to it. We are literally teaching, in some cases, old dogs, new tricks. And so it should be an interesting ride. Is there anything that you can give our listeners that would be a good takeaway in terms of, kind of best practices? I really liked what you were saying about making sure that your org chart is up to date and your, list of investors or beneficial owners, making sure that that's up to date, especially in connection with getting ready for a tax season and filings and whatnot.
So this has been fun. I know I agree with you, Teresa. It's going to be it's going to be an interesting year in the next several years to see how this plays out. With real estate clients, especially, I would urge them to at least reach out to their Dykema attorneys, reach out to whoever they have questions and whatnot. I think really being organized is key here, and making sure that and communicating, and then reaching out to us to whether we need to update their entity documents or to include that CTA language. If they need some spreadsheets, if we need to go out there and just make sure that we're meeting the deadlines, calendaring, those deadlines, especially for the reporting requirements. They may do it already for certain loan documents and whatnot within 90 days after, the calendar year or fiscal year ends. They have to do certain reporting requirements and send those to the lender. That may be a trigger for them to update their calendar to include these reporting requirements. So I think really just staying organized and definitely reaching out to us as a Dykema attorneys and for feedback and help and assistance in updating their document, and also providing any kind of assistance that we can on on future transactions, I think is key. It's just having that open line of communication.
I think that's great advice. And I would add, that a client or real estate company also might just want to remember their